I'm going to break one of the cardinal rules of presentations. You know, you're never supposed to ever mention anyone by name out of fear of hurting someone's feelings, but I will thank Lucy, Ellen, and Leslie specifically for all the work behind the scenes you've done to get me here today, and it's a real honor to be back here at the law school. This place means a lot to me. For the law students, you'll find out one day you'll look back and have fond memories of this, believe it or not, and so I really do appreciate that. So, how many of you have ever had an injury that caused a scar or a burn that you are just nagging you? A lot of you? Yeah? Even if it's on the stove, right? How many folks have ever had don't need to be too personal, but had like a surgical scar? Surgical scar? Yeah, me too. I won't ask for hands on this one, but how many of us, think about it, have a few nagging gray hairs? I'll raise my hand. Mine are mostly in my beard, with actually growing out. And there's a handful of us in here that have a hair loss problem. That's another issue. And I started losing my hair when I was 16. So by the time I started law school here in 2002, I can honestly say I have not owned a comb in this century. So another issue that faces many Americans and people all over the world for that reason. But for all of us that have had burns, scars, or injuries, loss of hair, gray hair, regenerative medicine, can offer a solution to that. And so we'll talk about today really three main areas. That being we're going to start off with the boring part. We'll talk about the law a little bit, and then we're going to go into and talk about what exactly is regenerative medicine. Talk about something just generally, and then finally we're going to go at a pretty steady pace and go through what I think are some of the frontiers in regenerative medicine, some of the hot areas, and talk about at each stage what might be patentable subject matter as we move through each one of those. So in terms of the legal landscape, we start out with 35 U.S.C. 101. And 101, for those of you that are IP students here, I can tell you 101 in practice has become so much more important than it was, even 10 or 15 years ago. I remember sitting in Tom Field's class, and 101 was something we just kind of talked about and kept moving and went on to 112, 102, 103. But now 101, especially in the regenerative medicine space, is incredibly important. And generally speaking, 101 sets forth the statutory categories of invention: process, machine, manufacturer, composition, and then, of course, improvements. But over time, the courts have kind of nibbled away at that and set forth what are called judicial exceptions. And, of course, these are laws of nature, natural phenomenon, and abstract ideas. So one of my all-time favorite cases, and again, law students, you know this one, is the Chakravarty case. And you can't talk about regenerative medicine without at least going back to Chakravarty and talking about this. Chakravarty himself was a genetic engineer, and he came up with a bacterium that was specifically formulated to break down crude oil. And so this was particularly important in the 1980s when we had lots of oil spills. So Chakravarty filed a patent application, appealed, made the case made all the way to the Supreme Court, and the question before the court then was, is the creation of a live human-made organism patentable? And the Supreme Court said, yes, it is, because it's human-made. So naturally occurring organisms are not patentable eligible, but anything that's human-made, if it is a live organism, is in fact patentable. So fast forward to 2012. We're starting to see regenerative medicine in the modern age really take hold, and we're seeing diagnostics become much more important. And this is the Mayo Prometheus case. And one of the patent claims at issue in this case claimed a method of optimizing therapeutic efficacy for treatment of immune-mediated gastrointestinal disorder. Quite a mouthful, right? But the point was the steps were involved were administering a drug, having a certain metabolite, and then determining the level of the metabolite in the blood. So I pasted the famous quote from the Supreme Court case, where the court basically said, if you're just reciting a process that involves a process that occurs in nature, no. You're not going to get anything here in terms of patent eligibility. There has to be something more. And so now, when you're prosecuting cases before the patent office, the examiners are looking for that something more, an additional step in your manufacturing process, an additional component in your composition, et cetera. So this case really set forth the precedent and the stage for going above and beyond what is needed past the naturally occurring component. And the last case I just wanted to set the stage with is the Myriad case. And in this case, Myriad actually patented a genetic test that involved isolating certain DNA strands and then also creating complementary DNA strands. So you had the isolation as well as the manipulation of DNA. And this involved what's referred to as the BRCA1 and BRCA2 gene. So anyone done 23andMe? Yes? Did you go beyond the ancestry and do the health? Anyone? Yeah, 1, 2, 3. I did too. I just got mine back actually on my birthday a couple of weeks ago. And not only was I shocked by the ancestry, that's a conversation for another time, but the health piece was very informative. I'm at high risk for Alzheimer's, so I got to watch that. But the other thing that stuck out to me was the BRCA1 and BRCA2 gene analysis that actually showed up in my health, and I have the mutation for that. And I'm like, so my wife's a nurse practitioner, so I go to her and I'm like, what's up with that? That's breast cancer. And my wife informs me, honey, men get breast cancer. I'm like, oh yeah, that's right. So I do need to watch that. So what they found now is men are at high risk when they have this mutation, the BRCA1, BRCA2 gene, for breast, prostate, as well as skin cancer. And matter of fact, 7 years ago, I had skin cancer. I had skin cancer on my nose, 28 stitches running down my face. Not know it today. I had a great surgeon at Duke. Did a great job. But sure enough, it all makes sense now. So I'm not getting paid by 23andMe, by the way, but it's actually worth it if you do spend the extra money and get the health analysis. But anyway, I digress. So in this case, the court held that naturally occurring DNA, of course, is not patentable just because you isolate it, all right? There has to be something more. In this case, when they actually synthesize the cDNA, man-made, great, patent eligible. So this was just in the news just a few weeks ago. I thought this would be nice to stress the importance of OneonOne in all patent litigation, especially in the regenerative medicine space right now. The District Court of Delaware is now having what they call OneonOne Day. And I put fireworks on this screen because now they're trying out a new program where parties literally line up and rapid fire argue 101, one case after another, where the case is dispositive potentially on a 101 issue. So this is really being done for judicial efficiency. So if you can dispose of a case over 101, no more discovery, no more motions. You save a lot of money if the case can be ended on 101, okay? So again, the point of all this background landscape is just keep in mind 101 can be very important from a patent perspective for regenerative medicine, okay? So regenerative medicine itself, what exactly is it? You could define this any number of ways. But generally speaking, you think of it as replacing, renewing, engineering human cells, tissues, organs, proteins, etc. And all this is being done to restore function to the body and get the body back to a state of what we call homeostasis. That's the ultimate goal. And usually regenerative medicine centers around the use of stem cells. So from a historical perspective, we go back to the 1950s. And that's when regenerative medicine really started getting its foothold. In the 1950s, we had the first successful kidney transplant in 1954. And in 1956, we actually had the first successful bone marrow transplant. And this is actually some of the early stages of what we refer to as regenerative medicine to this day. Move forward, peace, love, 1960s. You have the first successful transplantation of the pancreas, kidney, liver, and the heart, all in the 1960s. Hard to believe, right? Jump forward to my personal favorite decade, the 1980s. I love the Rubik's Cube. 1980s were fantastic. I still listen to the music all the time. So anyway, in 1980s, you had transplant surgery involving both single lung and double lung, okay? So you see these slow advancements, transplants from living organisms. And now at present, approximately 500,000 Americans every year get a transplant of some form, okay? So it's amazing how much progress we've had since the 1950s just in organ transplant. So who are some of the key players in the space that you need to be aware of? So first of all, let's think about this from a country perspective. Right now, the United States accounts for approximately 50% of all inventions in the regenerative medicine space, 50%. The other key players are Japan, Germany, China, and the United Kingdom, and they fall kind of in that order, believe it or not. Other key players in this space are, of course, universities and university hospital systems. Anyone go to the University of California? Anyone? No? How about Wisconsin? MIT? No? We had all those people in our class. What happened? Anyway, those are your key players, from an early perspective. Now, anyone from Texas? I'm not from Texas. I'm from Tennessee. That's the accent. Okay, no one from Texas. Okay, so another key player really in the last 15, 20 years is Wake Forest from my current state of North Carolina. Wake Forest has a fantastic regenerative medicine program. And in terms of hospital systems, Mayo Clinic, as one might expect, and right down the road, Mass General is a really strong program. Corporations, again, major players in the regenerative space. I could talk all day giving you a list of every startup in this space, okay? Enormous amount of money pouring into the corporations. In terms of the big players, you have on the tissue side, MiMedx, which is a large publicly traded company outside Atlanta. Osiris, which was just announced recently being acquired by Smith & Nephew. Smith & Nephew's always been a big player, but with the acquisition of Osiris, they're going to be huge. Integra Life Sciences in New Jersey. Just, there's large companies involved in this, and it's growing every day. Just to put this in perspective, in just the second quarter of last year, regenerative medicine companies raised more than $4.1 billion in one quarter. And at the end of 2018, globally, there were over 1,000 clinical trials going in the regenerative medicine space. And it's anticipated that the global market for regenerative medicine will pass $80 billion in the next few years. So now I'd like to go through some individual cell-based therapies, and these are sort of the cutting-edge things that you might read about in the newspaper or articles. And I'm going to start out with one of my favorites, and that's umbilical cord blood. I have worked with many clients over the last decade that are working with human birth tissue. I could do multiple talks about this, but I tried to pare this down. And to talk about umbilical cord blood, the point of isolating umbilical cord blood is ultimately to obtain the mesenchymal stem cells that are in the cord blood. Mesenchymal stem cells from the cord blood are actually very young. It's from a child, right? And this is opposed to what a stem cell you might abstract from bone marrow from someone like me in the older, well, mid-age. We'll go with mid-age. I don't have young cells anymore, okay? You don't want my bone marrow. But an infant, just born, cord blood, fantastic source of stem cells. So in terms of processing, if any of you guys ever, or women, witnessed a C-section, couple, maybe when your son was born, daughter was born, I have witnessed my wife had a C-section. It was quite informative. So we actually isolated and cryopreserved my son's umbilical cord and cord blood. Is cryogenically preserved in upstate New York as we speak. How is it extracted? Well, typically it's clamped off at either natural birth or C-section, and the blood is actually drained from the umbilical cord and then preserved. Now, the cord blood itself can be cryopreserved and stored for a later time. Some companies take it immediately while it's fresh and cryopreserve it. They might take it fresh, lyophilize it, isolate the stem cells. All different types of processing can be done, but the ultimate goal is to get the mesenchymal stem cells available for therapeutic use. One of the great things about umbilical cord blood, too, is I think the isolation of it can avoid many of the ethical issues. That when you say the word stem cells, people kind of tense up and think of politics or ethics, but all it takes is a female's consent to donate this tissue. And so I think it's a great opportunity to do more research, and it's a great opportunity for companies to isolate a great source of stem cells. So cord blood itself has been shown to really encompass, in terms of treatment areas, everything you can think of. All right, there orthopedic injuries, autoimmune disorders, you name it. So from an intellectual property standpoint, when it comes to cord blood and mesenchymal stem cells, if you think about the composition itself, think back to 101. If you're just taking the cord blood itself, that's not patentable. That's something that's naturally occurring. So you've got to do something more to it, add something to it, process it in a proprietary way. You've got to go further than just isolation, right? So think about that. Method of manufacturing, method of processing the cord blood is fertile areas for patent protection. And of course, any type of method of treatment with your proprietary composition would also be a good area for patent protection. Another cell-based therapy pertains to corneal disease. Right now, 45 million people suffer from bilateral blindness, so blindness in both areas. And of these 45 million people, 20% of that blindness comes down to corneal disease. So one such disease that's causing blindness is called limbal stem cell deficiency. And this is caused by very simple things you might not be aware of, such as trauma to your eye. Maybe you've been too close to a heat source, you've been in a car wreck, severe scratching, even simple things such as wearing contact lenses. I wear my glasses. I'm just not a contact lens person. But the lack of stem cell regeneration in the eye leads to multiple problems. In addition to vision loss, you can have glaring, cloudiness, etc. So corneal disease is a real problem. And so there's been therapies developed to transplant autologous stem cells, in other words, stem cells that are maybe in a healthy eye over to a diseased eye, and that's actually shown to work. So taking your own stem cells is fantastic. Great, it can actually work. There's also been research in focusing on allogenic or donor stem cell transplantation, so maybe a family member or someone taking their stem cells from the eye and transplanting into your diseased eye. That's being shown to work. So from a patent perspective on this, it's very similar. Anything that's pure, anything living directly out of the eye, probably not going to be successful in gaining a patent on that. But you may be processing it in a certain way. You're adding different components to it. Again, think about 101. Also think about how you're manufacturing or processing the stem cells. And of course, methods of treatment, once again. Also fertile areas for patent protection. Another huge area that everyone should be concerned about is diabetes. Diabetes right now is the 7th leading cause of deaths in the United States. According to the American Diabetes Association, over 30 million Americans have either type 1 or type 2 diabetes. So you're looking at close to around 10% of the entire population of the United States. Right now, diabetes costs, in terms of healthcare expenditures, about $300 billion a year. And just the fact people are suffering from diabetes results in $90 billion a year in just loss, just pure reduced productivity, days missed to work, etc. So it is an enormous issue. One of the older regenerative medicine approaches that we've seen over the last 10 years has been taking isolated islets from cadaveric pancreatic tissue and then instilling that through a portal vein into living diseased liver tissue, and that's been shown to work. And hopefully that'll continue to gain more traction. Another proposed strategy that's been in the news recently is a type of stem cell therapy that would be directed only towards those with type 1 diabetes, and that would be replenishing any sort of B cells that are present. And if you know a lot about diabetes, you know that B cells can be attacked and harmed from basically autoimmune type response. So if we can replace anything that's being harmed, great, and that's through stem cell therapy. So to flip to the intellectual property standpoint, again, 101, stem cell compositions themselves, probably not patentable. But again, think about how that's being processed. What are you doing in terms of how you're isolating it? Methods of isolation, methods of treatment, all different fertile areas on the method side. And then think about anything you're adding to your composition to get you over that 101 bar. Another area is disease, kidney disease. So currently there's a shortage of donor kidneys, and many people with kidney disease just never have a chance to get a transplant. In the United States alone, in 2018, over 21,000 kidney transplants were done successfully. So that's the good news. Bad news, 8,000 Americans die each year waiting for a kidney transplant. So to address the shortage of donor organs, there's been a few approaches that have been applied. One approach that we've seen in the news is to take what's called pluripotent stem cells from urine cells and produce kidney organoids actually outside the body, and then take those organoids and hopefully they can establish and replenish a diseased kidney. Another approach is gene editing techniques, and the really point of gene editing would be, and I have the picture of the pig here, very cute pig by the way, take the kidney from the pig and transplant that into a diseased human. So you're crossing from pig to human, which, as we all know, pigs are incredibly smart. They're very close to us, right? And so taking the pig kidney, installing it in a human, and it's believed, and by all accounts, it's believed that we are only 1 or 2 years away from actually pulling this off, okay? So keep an eye out for that in the news. So in terms of patent protection on this side, there's multiple areas where you could attack here. We'll talk more about 3D bioprinting in a few minutes, but that'll be another area to think about. Think about your stem cell composition that may be involved. Methods of transplant, how is a transplant being taken under? Methods of treatment or methods of manufacture. Another thing is, when you think about transplant, think about how you are preventing rejection by the human body, okay? That's a huge area. So there will probably be a lot of intellectual property come up around methods of preventing rejection by the human body, especially from a pig, okay? Another fascinating area for cell-based therapy involves the gastrointestinal system. So right now there's about 18,000 cases of esophageal cancer alone diagnosed each year. So in terms of statistics for men and women, that's a chance of 1 in 132 for men and 1 in 455 for women. One of the things that's been in the news recently about esophageal cancer is basically taking what's called a stem cell implant, and they take stem cells, they put it on a construct, and then they implant it into the esophagus. Maybe there's a diseased area of the esophagus that can be extracted, and the implant can be placed inside the esophagus to replace the area of injury. And so the hope is that if you can build a construct with stem cells, put it in the esophagus, then maybe there's a chance that that same thing can be replicated in the stomach, small intestine, large intestine, because at the end of the day, your entire pipe is coated with mucosal membranes, and it's very, very similar, okay? So the esophagus was sort of a natural area to start with, given its location. So the hope is we can extend taking the construct with stem cells and treating the entire GI tract. So again, this is particularly fertile for patent protection because you're combining two different things, an underlying construct or substrate with stem cells. So there's choices here being made. It's not something that's naturally occurring, so that gets you over the OneonOne bar. Methods of how you're transplanting, also methods of how you're manufacturing your construct and how the stem cells maybe mesh with the construct. Now, another focus of regenerative medicine is in tissue engineering, and me personally, this is where I have 90% of my experience. Wound treatment is enormous, absolutely enormous. In the United States, chronic wounds affect 6.5 million people each year. Chronic wounds, by definition, can be largely what we see as diabetic ulcers, especially around the feet, venous or pressure ulcers, as well as just typical burns. A burn victim can be treated in the regenerative medicine space. Over $25 billion is spent annually just on wound treatments, and that's globally. The U.S. wound care market is currently about $4 billion a year. So by way of example, what a typical wound can cost about $50,000 US to treat. Just one wound, one diabetic ulcer on a foot. So I personally have seen many approaches to treating wounds. One approach that's publicly known and been patented is injectable formulations of stem cells into the wound, and that can come from various sources. Most of the clients I've worked with have used placental tissue, amnion, chorion, umbilical cord blood. Another approach would be to actually build a membrane from placental tissue, take the entire cross-section of the placenta, so you've got amnion and chorion, and placing it over a wound. Maybe it could be lyophilized to a powder applied to a wound. If you do a membrane-based construct, it could be dehydrated and then hydrated at the point of attachment to the wound, or it can be attached with a suture, okay? So there's multiple ways of attacking wounds, and that's just using birth tissue. Birth tissue is just one source. There's multiple sources. Porcine intestines, pig intestines, various parts of pig skin, substituting for our skin. So thinking outside the box, wound treatment is just wide open. Now, from a patent perspective, I've worked with many clients in this area. I have faced many OneonOne rejections, but the key is to show that what you are doing, again, is different from what's naturally occurring. You've got to do something to that tissue. Even if you add a cryoprotectant or radioprotectant, you're doing something to that tissue to get you over that bar of just saying, this is something that I isolated from the mother at a C-section and I slapped it on a wound. Not good enough, okay? Got to do something more, okay? The next area, anti-aging and cosmetic. As much as you don't want to face it, we're all going to get wrinkles. We're all going to age, right? So when a human is born, there's an abundance of what's called collagen. Collagen is in our skin. So the body's production of collagen begins to fall off in your late 20s, all right? So it continues to fall until you hit age 30. So as soon as 29, you hit 30, then it really starts dropping, okay? So as soon as you hit 30, 31, sorry to report, it's going to drop by 1 to 2% every year after that. So enjoy those 20s and 30s while you got because it's all down here from there. So you'll start facing things, wrinkles, crow's feet. That's by the photo here. And this all boils down to less and less collagen in our skin. The plumpness, we have less elasticity. So we lose that firmness and elasticity, and we start to show age. It's just a fact, So in this area, you've heard of collagen injections most likely. Everybody's familiar with Botox, right? So everyone's trying to fight that aging process. And so now we're seeing injections of stem cells into crow's feet, around the eyes, areas where you typically see wrinkles or crow's feet. And the stem cells, and what I'm seeing in my practice are often isolated from adipose or fat cells. That's a good source. I've seen bone marrow stem cells be injected in and around wrinkles. And I'm also seeing umbilical cord amnion tissue also being ground up and injected into the face. It's potentially working. Also have seen bioresorbable polymer beads being mixed with all kinds of different naturally occurring sources and injected into the face. Again, everything's being done to restore, I don't think I have too many wrinkles, but to restore, maybe when I smile I have wrinkles, look in the mirror, get a shock, right? To restore that plumpness and firmness. So another area, and this is my absolute personal favorite, is hair, okay? You would not believe the amount of money that is poured into trying to restore hair growth and get rid of gray, okay? I have 2 clients in this area, and this is a huge thing. I have personally worked with a client that injected a certain type of stem cell into one half of his head and not the other half, and he has salt and pepper, we call hair, and it was gray and black. And no lie, this guy's left side of his head became jet black over time, and it actually worked. He looked like Two-Face from the Batman series, but it worked. I saw it firsthand. I would not have believed it if I didn't see it. So keep in mind, there are things that are being done to get rid of gray if you don't want to use Just for Men or Clairol, whatever that stuff is. If you don't want to go down that road, maybe this is an option. And also hair growth, you maybe don't have to necessarily rely on drugs that are taken orally, et cetera, or applied to the hair. stem cell therapy into the follicles is hopefully being shown to regrow hair. So from a patent perspective, many fertile areas here. Again, think about 101. I don't want to sound like a broken record, but again, 101 is your key. Gotcha. So folks that may not have heard what he said, if there's someone online listening, the answer was when from the FDA looks at, is it indicated to treat a disease? And of course, we could argue all day, are wrinkles a disease, or is hair loss a disease? There may be something, there's a genetic component, but maybe their disease is causing the hair loss. I don't know. Maybe there's some way to be creative there. No, I don't want to restart. Okay. So it's doing it again. Maybe I'll hurry up here. So moving on, go on. Another major area we'll talk about briefly is orthopedic and musculoskeletal. And all of this really boils down to soft tissue treatment. So 1 in 7 Americans have an orthopedic impairment of some type. So those of you, how many of you are avid runners in the group, or no runners? Okay, maybe it's bigger down south where we have a little bit better weather. But major runners in my subdivision all the time. I try to do 2 20-minute walks a day. That's more my style. I've seen too many things on this side that straight out running all the time scares me. But more than 3.5 million children ages 14 and younger get hurt annually playing sports. Not trying to discourage your kids from playing sports. That's not what I'm going here. I'm making a point that when you put your kid on the soccer field, there's a chance they will have a musculoskeletal injury. High school athletes account for 2 million injuries and 500,000 doctor visits every year, including 30,000 plus hospitalizations just for orthopedic injuries. If we went to the college and NBA, NFL, more injuries. And I know for a fact some of the NFL teams have used some of my clients' compositions to treat. So regenerative medicine is very much involved in pro athletes right now. The main driver with regenerative medicine and orthopedics is really trying to manage inflammation and drive healing of the musculoskeletal tissue. And so think about the focus of really being soft repair. So ligaments, tendons. Anyone hopefully has ever had a torn ACL? Any Division I athletes here? Maybe not. That's a major injury, and again, this is something that after that's maybe surgically repaired, stem cell treatment can help with healing time and restore the homeostasis of that soft tissue. So in terms of orthopedic applications, there's really 4 main areas that I've witnessed personally, and that's the use of what's called platelet-rich plasma. That's been used a lot. That's derived from an individual patient's whole blood, and it has a mixture of platelets and growth factors, and these all support normal cell activity in the soft tissue. Another is BMAC, or bone marrow aspirate concentrate, being injected into that soft tissue. Again, mesenchymal stem cells, we talked about earlier from cord blood, great way of treating soft tissue. And also, again, human amniotic membrane or placental tissue, fabulous source of stem cells. So from a patent perspective, again, think about 101. Compositions here could quite be patentable because you're more likely going to be adding something to what's naturally occurring. Methods of soft tissue treatment, methods of manufacture are all great areas from a patent perspective. One of the last things I'll talk about here real quick is tissue, from the tissue engineering as well as cell therapy standpoint, is bioprinting. People have probably heard of 3D printing. So the global 3D printing, oh no. Do I need to do anything? Okay. Oh, that's okay. I'm heading towards the finish line here. So the global 3D bioprinting market is about $1 billion. So compared to the numbers I've thrown around in this talk so far, kind of small, but it's gaining traction in terms of application in this medical space. Tissue and organ regeneration, as well as prosthetics and implants, is where you see a lot of work being done. The future growth will probably be likely attributed to the rising incidence of chronic diseases such as heart and kidney failures. I think that's going to drive 3D printing, bioprinting a lot. You have an aging population. You have a baby boomer generation that's getting older, and there's a limited number of organs. We talked about that. So the thought is 3D printing can be potentially used in the organ space. So in just this past October, the FDA actually granted a grant of $2.5 million to 5 research institutions, those being Harvard, Carnegie Mellon, Rutgers, Georgia Tech, and MIT. That's a lot of money for them to do research in the bioprinting space. So even the FDA is starting to recognize this could be a great future. So generally speaking, I don't know how much you know about bioprinting, but bioprinting essentially has the ability to deliver cells to a specific site, layer by layer, build what's needed, okay? So think of multiple layers building. In terms of applications, just a few weeks ago, Wake Forest and Winston-Salem, North Carolina, published a paper highlighting the use of an in situ bioprinting skin system. So essentially they can take a bioprinter, they can map out the size of the wound you have, and they can develop a specific depth and size of a skin graft from bioprinting with certain cells. It's fantastic. And this is really one of the first times we've seen it actually be customized to a wound. So check that out, Wake Forest. They showed that they could close a wound at a surgical site in 3 weeks. And to put that in perspective, it normally takes 6 weeks, okay? And I can speak to that from experience. In 2012, I was in Winston-Salem helping a friend restore a home. I ran my thumb through a table saw. I cut the end of my thumb off completely. I was rushed to Wake Forest and had surgery, and they rebuilt my thumb from my forearm. I have a scar to this day from my forearm rebuilding my thumb. If some of this technology would have been, implemented then, I probably would have had a little bit better outcome, but overall, I have an effective thumb. It looks a little weird. Don't come up and stare at it. But bioprinting would have been great to have a customized construct to rebuild my thumb from, as opposed to, cutting a chunk out of my forearm. So, again, great area that I think we're going to see more work in. I'll mention one other thing. UC San Diego published a paper just in January describing how they use a 3D bioprinting to print a spinal scaffold that they implanted in a rat. So that's great too. If you can reproduce spinal portions and do spinal surgery from bioprinting.
I'm asking this from the health law perspective. What's protected in that scenario? What are you protecting around? Is it the actual software for the bioprinter?
It can be. It can be the bioprinter itself. We've also seen patent, and also because there's many different type of bioprinting. Another hot area is, what are you actually using for the ink? Okay, you're using cells, right? So the composition you're running through that bioprinter could be proprietary to your company. Okay, and so yeah, the bioprinter itself, what you're running through it, methods of treatment with it, like with the skin, many areas for patent protection.
One of the other big issues that comes up is how are you treating it from a regulatory perspective in terms of what combination product or device or...
Right, totally. Yeah, I agree. So maybe we can talk a little more about that when I'm done, if you want. So the most anticipated part of bioprinting, I think, is going to be the bioprinting of actual organs. I read an article just last week that said the question is when and not if we will be bioprinting organs one day. So it's just a matter of time. From a statistical standpoint, in just January of this year, there were 113,000 men, women, and children waiting for or just some sort of organ transplant in the U.S. in January. In 2018, we had 36,000 transplants, and sadly, 20 people die every day waiting for a transplant. So you see, put that in perspective and think of turning on that bioprinter. Think of your inkjet printer sitting on your desktop at your home or in your office. If we have the ability to bioprint organs and grow them outside the body and transplant them, that would really address the organ shortage. So I had some notes here about the IP standpoint. We already talked about that, the printer itself, the composition that runs through the printer, et cetera. Great areas for patent protection. Whoops. So just a few final thoughts, and these are a bit random, especially for folks tuning in online that are in a startup. And I say engage legal counsel early with the exclamation point. especially regulatory counsel, absolutely, they are incredibly important, okay? I've seen so many companies that call me when they're so far down the R&D trail and they haven't thought about, oh, wait a minute, what do I need to actually introduce this to the market? What are my barriers to entry from an FDA standpoint? And the question back is like, well, what's the name of your FDA lawyer? Oh, well, we haven't engaged one yet. You know, it's like the Home Alone response. Like, okay, you need to engage legal counsel immediately on the FDA front. Also, a plug for the IP guys in the room, engage IP counsel already. That's not to say don't let the IP steer your R&D, let the R&D steer your IP, but at the same time, have IP counsel on board early. I think that's most important, especially before the launch of a product, because you need to get a freedom to operate clearance opinion done for any product you take into the market. Make sure you're not infringing another product. Also, don't underestimate the power of a great trademark. We all know trademarks identify services and goods. Have a strong trademark, especially in an area like regenerative medicine. If you can penetrate the market early in an area like this that's continually growing, you get consumer recognition. The trademark can be incredibly powerful. Copyrights, we're going to have a website, domains, etc. Trade secrets, another huge area. Some of this stuff may not be reverse engineered, okay? It may be better left to a trade secret. IP counsel can help you with that. And then licensing issues. We talked about licensing before. Get a good contract or transactional attorney on your team. They want to guide you through who owns the IP. I see a lot of these startups in the regenerative medicine space come out of universities, and that's when it gets really dicey. You know, a professor thinks of something, he starts a startup company. Who owns the IP? Huge question. So in closing, I think it's safe to say that the regenerative medicine area is exciting. It's growing. I think it has a bright future. I think we're going to see improved outcomes with organ transplants, with diabetes. I think we're going to continue to see better wound management. That's already been well advanced, but I think it can even go further. I think we're going to see more musculoskeletal issues be resolved, soft tissue repair. And with a little bit of luck, we'll all look a little younger, have a little more hair, and a lot less gray, right? Okay. I appreciate your attention today. I hope you found this interesting. I do. I love this area. And if anyone has any questions, we can talk about it now. It's 12:50, so we didn't take the full hour. If you don't feel comfortable asking questions, come up and talk to me afterwards. I'd be happy to talk to you one-on-one too. So thank you for having me. I've enjoyed it.
So how do you manage any of the difference in terms of the strategies that when you're dealing internationally versus the United States?
That's a great question, and that comes up every time is what do we want to do outside the United States? And one of the biggest issues we always talk about with our clients is what's the regulatory aspect? Europe is an entirely different ball of wax from the U.S. I mean, I wouldn't even begin to know where to start. And so we usually have to tell our clients, if you're going to have any interest in launching this in Europe, you need to talk to your regulatory counsel in Europe first. And then hopefully all those conversations take place before we get to the 30-month date on our PCT. Because by that date, you can't extend the national stage deadline, right, for the patent folks in here. That's not extendable. So it's all about timing. So a lot of times we file a provisional. We wait a full year. We might file a PCT and a US on the same day. Hopefully we'll get something from the US examiner. We might file it as a track 1, expedite that prosecution, get an idea of what's patentable, and then make a decision, potentially before the 30-month deadline comes for international filings. And all the while, good timing, all the while, they are continually considering the launch of product potentially in Europe and other countries. Most of the clients I work with, it really comes down to the US for sure, and Europe is always the question mark. Sometimes there's other countries. It really just depends on what it is. There might be some in South America that might show interest, but right now, or in Asia, but right now the US is so dominant in this area. I have some clients that don't even, they're like, this is all I can handle. If I can sell into the size of the market of the US, that's all we can do right now. We just can't do any more. So hopefully that's a long way of answering your question. Any more questions, comments, thoughts? Okay. Okay. Keep.
This is fascinating. Thank you so so much for this. In terms of the clients who, as you're strategizing, have any of your clients been grappling with the ethical issues around the regenerative medicine, or more importantly, the organ development and making it available to clients? And
Not really. I'll be honest with you. It's not really come up. No.
They're probably addressing that need as opposed to suffering from
Right.
Yeah, I think that's the way they. Yeah. I mean, two clients I'm thinking of, especially in the wound treatment space, they view it as we're taking a product or a tissue that was going to be disposed of in an incinerator in a hospital. If we can get this woman to consent to donate the umbilical cord and the placental tissue, we just took that, from full consent, and now are using it to make a product that can help others. And so and I think that's a good way to look at it. If it's something that's going to be donated, I think you can get around a lot. I mean, tell me if I'm wrong, if you see that as.
Well, I was thinking of it more on the other end. So if you're
Okay.
able to create a new organ or new
Gotcha.
tissue, how do you make it available in an equitable
Gotcha.
way in the healthcare system?
Oh, right. That's a great question. I mean, from a corporate standpoint, sadly, that's going to be driven by money. So, you're right. There would be an ethical component to that. Is it only those who have the money to pay for it? I don't know. Well, on some of these products, my clients, they actually have an insurance reimbursement. So anyone with insurance, which hopefully that's everyone now, since Obamacare, but insurance will reimburse for much of the wound treatment, and so that's not an issue. But you're right. What if bioprinting organs is cash pay? What do you do then? Is it only the rich that can get a transplant? No.
Where it may come up.
the reality is most of the products are not organs.
Yeah, that's
Probably
right.
haven't been for 30 years, so you're not, but where it comes up is during the development stage for devices. Unlike for drugs, you can sell your products when you're in the development stage at cost. So some companies will choose to do that because they're small companies and they're trying to finance their operations. And that may not be reimbursable by insurance because it's experimental. So then you have people who can afford it, who can't afford it.
Good point.
The question you asked before, I'll just make this comment. When you're thinking about all of this from a regulatory point of view, the first question you need to ask, and it probably really affects your IP strategy as well, is, it gets to your one-on-one issue, is how much of the activity is the practice of medicine versus the practice of being basically the drug or pharmaceutical or device business. A lot of these regenerative medicine techniques are invented by doctors who just think they're practicing medicine. So that's why they don't think about talking to lawyers. They don't think about who owns it. They realize, oh, I'm doing this with a few patients and it worked. Now we're going to.
Yeah, roughly, I'd say 50 to 70% of the clients I interact with are MDs that have started companies. That's exactly right.
And so if they're only practicing medicine, it's probably not regulated by the FDA. It's when they start selling it as a product to
Yeah.
someone else to practice medicine.
That's right.
So, and I don't have much knowledge in this area, so bear with me on this question. Now, is there an expedited FDA pathway for regenerative medicine if it's need-based? So that's kind of.
They have a similar expedited pathway.
Okay.
But what the FDA did was they adopted a whole bunch of rules for some types of regenerative medicine, which seem to be completely contrary to everything you're going to be doing getting IP. It has, in order to get, it's not just so much an expedited path, but in order to get a reduced regulatory burden for approval of a regenerative medicine product, you have to fit into the category of products that are basically just transplanting what you're receiving from someone else.
Minimally manipulated is the term we run into. So
basically, you're taking something that's from one place and putting it into the patient for exactly the same purpose it was performing in where the donor was.
Right.
So a blood transfusion, things like that.
So a lot of times the FDA side of this is at odds with the IP, and I fight that every day. And I had this conversation. I think I mentioned to you, Leslie, I kind of thought the presentation might be there, but I've kind of changed it. But one of the things we could talk about for an entire presentation would be where the regulatory meets the IP, because to get through the FDA, you need to be minimally manipulated for like the wound treatments. Well, if you're just minimally manipulated, the patent office is going to be like, hello. That's naturally occurring. You haven't really done anything to it. So how do I get over OneonOne but satisfy the FDA? I can't do both. So it's a very fine line. That's a great issue you raised.
You have to figure out what's more important, getting to the market or getting the IP.
That's right.
And having exclusivity.
But there's also, you might get comment this, there's also exclusivity on the FDA side. There's is there data exclusivity or market
Only if you're not manipulated.
Right.
So
Okay.
if you're a biologic or a drug,
Yeah.
you then get regulatory. If you're a biologic, you get 12 years regulatory exclusivity. So it helps justify the investment independent of vendors.
Right. So that's kind of a fallback position in terms of exclusivity might be on the FDA side from a data or market exclusivity. For
I almost think that the minimally manipulated is what's covering today's therapies, but all the great stuff you're talking about is not going to be manipulated.
Right. Some of this goes way beyond, but I do see this in the tissue engineering side. I see a lot of the minimally manipulated versus one-on-one issue all the time. So I've talked to FDA folks. I'm Southern in DC, and I've talked to examiners regularly, and the consensus among them is they each say, I don't care what that branch of the government said, this is our role. And my fear is always going on the record saying something that contradicts something my client is also saying to the FDA. So I like for everyone to be on the same page, telling the same story. And if we can't get the IP, maybe that's okay. Maybe there's a trade secret we can rely on. I don't like inconsistent stories between two government agencies. That just upsets me. So, okay, I don't think that's a good idea.
You were well trained, clearly.
It's worse than getting upset, though. The largest patent case a client of mine ever lost was because an FDA filing had a typo, and the court determined that the typo was the truth, even though it wasn't.
Okay, there you go.
I did, yeah. So with the bioprinting and sort of the potential that has, I don't know much about how that functions, but I was wondering, kind of alongside that, do you see very much IP or innovation in sort of like incubators to sort of hold, a printed organ until it can be placed into
I think that's a
somebody's,
great idea. I think you will see that. I think right now that we aren't at a point where we've actually bioprinted yet an organ that can function outside the body and be implanted, but I think you're absolutely right. I think that'll be another great area that we'll have to, because unless you can, I don't know how long the process takes. I don't know unless you could bioprint it in real time and have the patient open up ready to go. It's like you think about hearts or lungs, be putting in an ice pack and then put on a helicopter and taken somewhere. I don't know. I think you've raised a great point. So that could be definitely another area for IP protection. Absolutely. Okay. Thank you. Appreciate it.